speaking to you right here at the East African Law Society in Arusha, Tanzania. And I hope you have been keeping safe. I hope you have been keeping well. And if you're in a chilly area like I am, I hope you are taking a hot cup of coffee or something to warm you this afternoon. And this afternoon, it's not just coffee that will warm you. We have this very fantastic session on mastering construction law disputes. And we are very privileged to host quite a distinguished panel of ladies and gentlemen who have distinguished themselves in this area of practice. And the session will be moderated by none other than Ms. Cynthia Kwendo, who is a seasoned advocate in insolvency and business restructuring at LegalMark with over 5 years of experience in legal practice. She specializes in commercial litigation with additional expertise in employment law, banking and finance, contract advisory, commercial debt recovery, alternative dispute resolution, and construction law. So prior to joining LegalMark, Cynthia worked at Sabiti and Company Advocates, where she handled legal briefs related to land disputes and construction law matters. She holds a Bachelor of Laws degree from Makerere University, a postgraduate diploma from the Law Development Center in Kampala, and she's a member of the Construction Law Committee of the East Africa Law Society. Cynthia is also a compliance officer at entities including Merita Emergency Medical Services and Uwezo Emergency Health Services. And in this capacity, she advises on key aspects of day-to-day operation of those companies. What a portfolio, Cynthia. It's really an esteemed honor to have you this afternoon. We hope to leverage on your wealth of expertise in moderating this session. Ladies and gentlemen, the session is streaming live on YouTube and on Zoom. So let's get sharing those platforms. We'll be sharing with you a hashtag on Twitter so that the conversation can start and proceed. Otherwise, Cynthia, you have us for the next 2 hours. So you can take us away now. Karibu.
Oh, thank you so much, Gabriel. I hope I'm audible enough. Good afternoon, ladies and gentlemen, distinguished colleagues, distinguished panelists, fellow legal professionals. My name is Cynthia Kwendo, and I have the privilege of moderating on this panel. The title of this panel is, the title of the masterclass today is Mastering Construction Disputes in East Africa, Winning Strategies for Lawyers. As we all know, construction law is an emerging sector. It's really growing rapidly, especially in East Africa. If you look at the infrastructural developments, a lot of money is injected into this sector. We also have a statistic of 30.6% of Africa's infrastructure developments being in East Africa. So this is a very good area of the law. It's something that we should all, really pick an interest in and also invest and see how we can learn from there. So here with me, we have different panelists that are going to give us going to take us through the relevant topics and also help us understand what the construction industry is about, the foundation for regional development, and also the cross-border issues that arise, cross-border investments, cross-border law enforcement in construction law, and also the contract misalignments, regulatory framework. So I'm really honored to have the distinguished panelists with me today. And first and foremost on our panel is Mr. Milton Ochen, who is an advocate of the High Court of Uganda and also a member of both the Uganda Law Society and the East African Law Society. Mr. Milton Ochen is the managing partner at Milton Advocates Kampala. He holds an MSc in Construction Law and Dispute Resolution from the British University in Dubai and has 15 years of experience in arbitration and major infrastructural projects, including the new Nile Bridge and Oil Roads project. He is a board member of Uganda's National Building Review Board and an accomplished educator and legal advisor in construction law across East Africa. He's going to take us through the topic, Emerging Trends in Construction Law. Ladies and gentlemen, distinguished panelists, members of the profession, join me in welcoming Mr. Milton Ochen to take us through this presentation. Thank you so much, sir. You're welcome.
Thank you, Cynthia. Thank you, my fellow distinguished speakers. A pleasure for me to be here and share and also learn from this wide range of speakers with vast experience in construction law. I always tell people construction law is extremely wide, and every day is a day really to learn. So much as I'm here to present, I'm also here to learn. The topic that was given to me today, you've mentioned the theme, but the topic that was given to me is Introduction to Construction Disputes and Common Causes. And that is what I'll be dwelling in. And if time allows, there are other topics. I do not know whether time will allow, but there was a second and third topic. But this is the main topic, Cynthia, that you gave me to look at. Gabriel, if you're there, you could help me share that. Just share those few slides that I've shared with you for purposes of this discussion. I'll go straight. Given that I'm the first speaker, allow me some few minutes lay a foundation that other speakers might find useful, to build on. Because again, the assumption is that what if somebody is participating in this webinar for the first time and would like to know some basic understanding of what construction law or what happens in the construction industry. First and foremost, I think, in my humble opinion, it's very, very important that we understand certain things as regards specifically construction. Construction is a unique. You can go to the next slide after that. That's my bio. Yes, there. You can leave it there for now. Construction is a very unique. Area of practice. It's a very unique area or sector or industry that has its own underlying participation and playing. So one, the role and relationships. Construction involves a wide range or involves a series of different specialists or players in the supply chain contributing to the same work but at different times. That is one of the unique things about construction. Just imagine you have a project. I'll use, for example, the NSSF Pensions Tower, which is bound to be the tallest building in the country. That many are participating at the same time to produce that work. So that makes construction very unique. And from that interaction of the different players, several disputes can arise. These people have widely different skills. They have differing skills. They work for different organizations. As you'll know, that construction is one of those areas where you have different you have a main contractor, you have subcontractors and specialists. You have one dealing with fire and safety installations. You have one dealing with mechanical and engineering. You have others dealing with all other sorts of things. So it's a beehive of activity of individuals. So all these people have different skills. They're working for different organizations. The level of understanding sometimes between them is less than would be desirable. And this plays in my humble view, lays a foundation to some of the disputes in construction. There can be several perennial problems that can stand in the way of effectively having a project completed. And that is very, very important. But majorly, we have three And I think my brothers and sisters who come after me will discuss that more in the other topics. But there are three critical players. You have the client or the employer, and that's the owner of the project. Now, within that particular individual, whether it is an institution or a normal human being, there's a representative who is the employer's representative, so you can call them a project manager. You have a category of advisors, especially, for example, where there's an advisory group, there is a feasibility consultant. Then you have stakeholders. For instance, the Nairobi market is leading a lot in construction of condominium units for sale. You have end users, you have the general public, you have tenants, you have the workforce, those are stakeholders. So you have suppliers also. Sometimes in a project, clients have direct, suppliers, or preferred suppliers for that matter. Then you have this person who is in the middle, who is an advisor or a consultant. This deals with design leadership, issues of management, administration, inspection, and sometimes financial, depending on the financial arrangement. Then you have the contractor who is providing the overall responsibility. This is the builder, this is the general contractor, the main contractor, called in different names, the principal contractor. That contractor can be a design and build contractor, so he's in charge of both the design and also the construction itself. Then you have the contractor's staff. You have managers, the planners, all that. And then you have, partial responsibility under the contractor, especially if it is an engineering contract, and so on and so forth. That is how the structure looks like. So you have a client right in the middle, and then you have all sorts of people surrounding that construction client. You have end users, lenders, investors, in some cases, insurance providers, design team leader, main contractor, facilities managers, and many others. So I thought it is very important that we point out this uniqueness in a construction setup, which lays a foundation for our understanding of disputes. It's also very critical that we look at the types of risks in construction, because as I believe my brother Huntington Amol will come and explain, when drafting these construction contracts, the main reason why we do these construction contracts is for proper allocation and distribution of risks. If they are not adequately or equitably distributed, that's a disaster for disputes. So there are several risks. They can be broadly categorized in terms of time, cost, performance, or quality, health and safety, and even perhaps environmental risks. But broadly speaking, you have management, direction, and supervision. Then you have physical works as a type of risk itself, where you have ground conditions, artificial obstructions, weather, defective materials or workmanship. You have delay and disputes, as one of the causes of disputes here. So all that in terms of possession of sites, late supply of information, insufficient execution of work, delays in their, issues of, damage and injury to persons and property. We also have external factors that affect the progress of works as a risk. We have payments. This is one of the biggest causes of disputes in construction. Either it is delayed payments, or in terms of certification, it is delaying settling claims. All these are causes of disputes, because the lifeline and the blood life of any construction project is money. And where money, is not flowing well, you have a challenge, and it could lead to a potential dispute. So we also have law and arbitration. As the choice of law that you prefer in the construction contract will determine how the disputes are resolved, because of the choice of law that has been made. I think also it's very important for me to note that construction is very, very largely contractual in nature, such that if a dispute occurs, those risks that we have been talking about are in the contract themselves. You have compensation events, which leads to claims and so on and so forth. So allow me just talk about these disputes the disputes and potential claims and claims themselves. A dispute, we all know, is a difference in opinion, but specifically to construction, a dispute will most times, in my experience, be about interpretation within the contract, a fair time extension, a fair payment for added work, or a fair payment for unanticipated work. It is important to note that a dispute turns into a potential claim whenever it is not resolved. It turns into a potential claim. So if the contractor can't reach an agreement on a dispute, the contractor is obligated under the contract to begin or initiate a potential claim process. This is normally well articulated in the contract in terms of time and what needs to be done, but is always initiated through a notice. Once a potential claim is received, it doesn't mean that parties should now retreat and begin fighting each other in their corners. It doesn't represent a failure on your part. It just means that it is a process. It's a contractual process, and that's why I emphasize that construction is largely very contractual in nature. I would also like to say here that that is just a process leading to a resolution of a dispute. If you realize in construction contracts, they're normally dispute resolution tier mechanisms. Some of them are internally within the contracts, within the framework in the contract, starting with the project manager or the engineer. And if that is not resolved, it can go to, depending on which contractual framework is applicable to a particular case. It then goes into adjudication and arbitration and so on and so forth. So it's a process. A claim basically is the last step in the process. It basically means a demand for monetary compensation or damages arising from or relating to performance of a contract. It is very critical that in resolving disputes or dealing with claims in construction, one follows the contractual notice procedures under the contract. Otherwise, one might stand to lose their claim or mismanage the dispute for that matter. I'll talk about construction contract components. You have project plans, you have project specifications, site information, you have employers' requirements. All this is what informs the construction contract components. But it's important to always master the hierarchy. In the event of any misunderstanding, which one takes precedence over the other. Most construction contracts will provide for the hierarchy that is applicable, but it's important to know that. I'll talk about legal responsibilities. There's what is called the spear-in doctrine. It arises from a Supreme Court decision in the US about 1918. And under this doctrine, the owner impliedly warrants that constructability of plans and specifications, of course, subject to the kind of the procurement method that has been used, the kind of contract, that would not necessarily apply so much, but also in where it is, for example, the yellow Fiddich book where you have design and build. What I'm trying to say is that this particular implied warranty is subject to the kind of contract that the parties choose. Because if a contractor is going to do design and build, then a lot of responsibilities, both design and liability relating to the construction itself, rests with that contractor. It carries both. So the other important aspect under this doctrine is the contractor is liable for defects resulting from the contractor's failure to perform work adhering to the plans and specifications. The other one is that the contractor is not liable for defects caused by mistakes in the owner's plans and specifications. Again, while applying this, we need to be mindful of the test of a prudent contractor in construction, a prudent and experienced contractor. There seems to be, of late in recent developments, the duty on the contractor on a prudent and experienced contractor to inform the project manager or the engineer if they think in their experience and knowledge the kind of designs are not going to be able to work, and then that will lead to an initiation of some processes of a change order or variations for that particular matter. It is important also to highlight, again, the 15 minutes is a very short time, so I'm trying to compress as much as possible, Cynthia. Public agency responsibilities, or these are basically the employer's responsibilities. As we go into the disputes, we need to understand who is supposed to be doing what under the contract as it distributes the risks, obligations, and liabilities. For the employer, or for this matter, public agency responsibilities, creating plans and specifications, providing bidders with all the relevant information, including even the difficulty to construct, undertaking geotechnical surveys for the benefit of the contractor who is going to do the work, awarding the contract to the lowest responsible bidder, availing possession, site possession to the contractor, providing sufficient supervision by appointing somebody who is competent to do the supervision for that matter. And most importantly, of course, making timely payments. For the contractor, responsibility is really, the contractor is to do the work as directed by the contract, or as directed by the engineer or project manager, follow contract procedures for disputes, comply with all claim notice requirements under the contractual framework, document time and materials for extra work, file timely claims pursuant to the contract. Let me go to the types of claims. Claims you have under the category of contractual claims. These are normally to do with ambiguous parts of plans or specifications that are part of the works. These will lead to disputes, and eventually will lead to claims. Change in work or materials, contract schedules and updates, issues, administrative deductions, quantity disputes as well will fall here. So we also have, again, this also cuts across in the risks in construction. Physical claims, these normally arise from differing site conditions. This is where physical conditions differ materially from any of the, what is provided in the contract documents, job site examination. Normally, a contractor would go and examine the site pre-contract execution. Physical conditions of unusual nature, differing materially from those ordinarily encountered and generally recognized as inherent in the work provided for in the contract. The other common causes also that contribute to disputes in construction, we have contract changes. You can call them in different names. Contract changes and extra works. By signing the contract, it is important to note that the owner or by signing the contract, the owner and the contractor and all subcontractors that fall into that supply chain agree that the owner, one, has the right to make changes, that the contract dictates the procedure for changing work and paying for those changes. Normally it is in the contract, and I believe Hamilton will touch on this as a way of drafting the clauses that avoid disputes. Contractor is required to perform the directive despite, even if you disagree. If it is an instruction from the engineer, you're supposed to do it, but also it contributes to disputes. Any changes to the contracts must be initiated through the contractual procedure of the contract change order, which must be in writing. The other area that always causes lots of disputes, common causes for disputes in construction, you have delay issues that cause disputes. So these delays, we can classify them into three. We have excusable delay. This is a delay to a controlling activity beyond the control of the parties that extends to, that has the impact of extending the project completion date. This is beyond the parties' control. That is very important. Inexcusable, this is a delay to a controlling activity caused by the contractor or client that extends the project's scheduled completion date. Then you also have categories of of concurrent delay. This is where both parties contribute to the delay, and then a determination of the dominant party that causes delay would then take liability. It is important also to discuss issues of liability. Generally, the owner is responsible for delay when it is caused by its own actions or inaction adversely affecting the progress of works as performed by the contractor. And in construction contracts, mostly these are, they can also appear among the compensation events, and there the contractor will follow the procedure to request for compensation, whether time or time and cost for that matter. So, for example, owners prevent contractors from proceeding with the works. The owner has a plan which is approved, and then tomorrow comes and starts changing. That has the effect of, as an example of a delay caused by the owner. Adding work, you add work to the contractor and you're not adding time. Again, remember the other principle, the rule of the thumb when it comes to allocation of risks. When you add work to the contractor and you do not add the contractor time, that is bound to cause a dispute. It's something that falls within the employer's mandate to extend that time for the contractor to complete that. So that becomes unfair and causes disputes. Owner does not deliver all areas of the site. You have the site as a contractor, you have partial access to the site, the other site is not there, the other part of the site is not there. That causes disputes a lot in construction. It is also important to analyze delay claims where you have non-critical delay. These are delay to activities that were never on the critical path. Normally in every construction cycle, there's a critical path, and therefore anything that comes to affect the critical path becomes a non-critical. That does not affect is a non-critical delay, and what affects is a critical delay.
You have
Yes,
like
please.
5 more minutes.
Okay, thank you very much. I'll wrap it up in those 5. The other area that is very important, as mentioned earlier on, that construction, it is very rare that you have a construction project that is singularly executed by one contractor. In construction, it is recognized that the contractors normally subcontract to different specialists. So that raises issues. There are subcontractor issues which are very prevalent in causing disputes. Because they are agents of the subcontractor, they are not privy, or the doctrine of privity comes to apply, they are not directly working with the employer. So in between there are communication issues that arise. Allow me also touch on contract administrative remedies, which is also very, very important. But let me rush to dealing with potential claims. Like I said at the beginning, disputes will lead to claims eventually if not resolved. So it is important that in advising our clients as lawyers, we know how to advise them when dealing with potential claims. It is important to review these potential claims. It is important to follow the notice of potential claim, keep records very thoroughly. Always you ask for additional information or supply additional information. It's very important to do that. Anticipating claims, what are the signs and symptoms that these are likely to cause disputes that will escalate into claims? You have to notice some of the things if you're advising the clients, or you advise the clients to watch out. Unusual pre-construction questions, notice of potential claim, that is a red flag that is telling you that something is coming. Unusual volume of contractors' correspondences. When the contractor writes a lot, there could be a problem. A failure to adhere to schedules, so it's important to track those schedules. Failure to obtain materials, failure to schedule subcontractors, subcontractor employees, problems which spill over. For example, if a subcontractor has employees who go on a strike, that is likely to affect the main contract works and causing disputes and claims for that matter. It is important to understand also defending claims. The rule of thumb is basically document everything. This is what I always tell my clients, and it's important that everything is documented, whether it's equipment and laborers on the projects. Take regular photos and videos. I always tell my clients, always write, always take photos, always have videos of the works that you're doing. For example, you are instructed to build, you build, and then tomorrow the engineer comes and says demolish. Take pictures and photos and videos of that demolition, because it will have a cost implication that will be useful in defending the claims and disputes, depending on which side you are at. Beware of current important activities. That is basically tracking, which is very, very important. Lastly, let me talk about evidence in construction disputes. I've also had the opportunity, apart from acting as counsel, but also participating as an arbitrator. And every time I have a claim before me as an arbitrator, I've learned that evidence is very, very, it will come down to proving your case for the claimants. It will come down to defending your case as a respondent or defendant. So most of the evidence you'll find in construction disputes is found in contract plans and specification, pre-construction meeting documents and minutes. Those are very critical. Change orders, schedules and monthly updates, daily reports. Those are very, very important. Correspondences, these are letters and emails. You'll find that parties, while in this communication, their communication will have an effect or impact on the contract itself. So when it comes to a dispute, proving what you're saying, whether you're claiming or defending, is very important to keep this. Submittals and RFIs are very, very important. Instructions, again, photographs and videos are very important. Valuation certificates and those interim payment certificates, especially where you have a claim that, for example, deals with charging of interest on delayed payments. It is very important that you keep this, because the time you're going to be tracking time to be able to properly claim under that. Financial remedies for breach of contract, because at the end of the dispute, somebody is asking for something. It will come down to money. Like I've said, the lifeline of any construction project is money. There's no contractor who is doing charity. It comes down to money. So financial remedies, you have general damages, liquidated damages, quantum merit claims. Sometimes within the contract, within the contractual framework, you have non-payment remedies of setting off or where there are cross claims, a contractor cross claims or the employer cross claims. There's a counter set off there. So what is due to who is reconciled, and that also provides a remedy. It is also very important that sometimes when disputes, before they escalate to the worst situation, it is important to deal with suspension and termination for that particular matter. It does help. Suspension of works, termination for breach, and termination for convenience. Sometimes we have to advise our clients to look at these options as a way of dealing with disputes that are at hand. Dispute resolution, lastly, where we have, I believe one of the distinguished speakers might cover this, where you have the non-adversarial ways of dispute resolution, which is contractual within the mechanisms in the contract. Then you also have adversarial, which are within where you have adjudication, arbitration, and litigation. But last but not least, it is very important while dealing with these disputes in construction contracts, always follow the what is called the C's principle, the cause, effect, entitlement, and substantiation in dealing with these disputes and the claims. Cynthia, thank you very much. I believe I've managed to wrap it up within the 5 minutes. Thank you.
Thank you so much, Mr. Chen, for that very elaborate and thoughtful discussion. My take home has been on documenting, having evidence, because in construction law, you know, you need evidence also on the ground. That means video evidence. So that has been really insightful. The only question I would have for you is on the role of technology in BIM, like BIM especially in detecting early dispute detection and prevention. That's what I would have for you. Thank you.
Thank you, Cynthia. Let me not assume that everybody will understand what BIMs or BIM means locally within the Ugandan construction industry. And again, allow me to use this opportunity to correct. I'm no longer a serving board member on the National Building Review Board. My tenure ended last year, so I'm no longer there. But while there, we developed a tool called BIMs, which is used. It's an online tool for application for example, for building permission to the building committees. We call it BIMS, the Building Information Management System. But the BIMS, I believe that you're referring to, is the Building Information Modeling. Basically, it's an that is the acronym. BIM is an acronym for Building Information Modeling. It describes the means by which everyone can understand a building through use of a digital model. So modeling an asset in digital form enables those who interact to be able to have a visual and see how they are going to interact with this building based on the various roles they are going to play in that. So there are there are two main features of BIMs. It's a digital tool which helps to optimize output both in terms of working practices as well as the life value of the project as well. It is also a project management tool. So in answering your question, having understood what BIM is, so what it basically does is that it encourages a collaborative approach to construction. Because this digital tool, the different players will be logged on. And it will be similar to smart contracts where you have a distributive ledger. And in that distributive ledger, several people have access to that tool. And they're able to see who is doing what, who is supposed to do what. But also, most importantly, the BIMs comes with several components. You have the BIM protocol, and this explains who does what, when, and how. So if people understand when they're supposed to do something, how and when, that helps a lot in mitigating and avoiding disputes because it is clearly explained and it is digital in nature and everybody can understand. You have a BIM execution plan. Again, as we've understood that construction involves a beehive of activities, but we all must be able to achieve one purpose. It's about movement of troops, coordinated movement of troops to achieve this project on time, quality, and within cost. So BIMS is going to be able to help every party, whatever they are doing, such that you're not behaving like some of the service providers. When a layer of asphalt has just been laid on the road, the telecoms people come and chop it into two, and you have a problem there. So it also has what is called an execution plan. I've already mentioned that in addition to the protocol. It also have an information manager as a tool. So it's very important. So all these coordinates, and then you have the common data environment where data is shared. If I want data for purposes of doing something that I'm supposed to do within the project, I am not going to start chasing a particular person who may not even want to give it to me. So within that digital tool, you have access to that information. So you can't, for example, a contractor can't claim that I've been asking for the plans and specifications and drawings and I can't have them. So that in many ways helps to reduce, disputes, avoid disputes in construction. Thank you. That is in a nutshell, but it's a subject for a whole day.
Thank you so much, Mr. Chen. Thank you once again for that insightful discussion.
Cynthia, you've muted yourself. Sorry.
Oh, sorry. Thank you so much, Mr. Ochen, once again, for that insightful discussion. There are very nice comments coming in. Abby says, thank you for the presentation. They're asking for the slides. We'll share with them later on in your emails. Someone is saying, this is really insightful. Thank you so much, Mr. Chen, once again.
Most welcome. A pleasure to have me. I'll stay on to learn from others as well.
Yes, please. So without further ado, allow me invite Mr. Hannington Amol who is a partner, managing partner of ALP Kenya. He is going to take us through the topic of drafting and managing construction contracts. Mr. Hannington Amol has notable experience in commercial transactions and regional construction contracts. Without further ado, Mr. Amol, please take us to the next presentation. Thank you.
Thank you so much, Cynthia. And Milton has really summarized what you are going to do today. So I'll try to just brush over so that I can give chance to colleagues also to bring in their contribution. I have some slide here that definitely I would like to share. So for this afternoon, for the next 15 minutes, mine would just be briefly to ask ourselves, what do we do to save ourselves from potential disputes in construction situation? Milton has already indicated that there are scenarios or things that could easily lead to disputes in contract situations. Cynthia, can you confirm that my screen is now visible?
Yes, it is. Your screen is visible.
Thank you. And so, what exactly do we foresee as likely to bring disputes? When do we foresee this? When do we troubleshoot? And how do we avoid it? At the very beginning, lawyers must understand the reason why we do contracts. We don't do them so that we have nice books or volumes of documents filed away to enable us get fees. The whole point of contract law is to avoid disputes. Otherwise, the contractor and the employer would just meet, agree on what is to be done and the payment terms, and shake hands, and work continues. But we document this in order to avoid disputes. So if you are going to draft a contract, a construction contract, which has no dispute avoidance or dispute management at the core, then you'd rather just let your clients have oral contracts. Mistakes in, or rather disputes in construction and other construction contracts arise primarily because of three things. One, poor drafting. Two, thoughtless negotiations. And three, mistakes during management of the contract execution, which would say, limitations or defects in contracts administration and contract management. I believe a colleague will talk about contracts management and some tools in dealing with them. So as a lawyer, mastering the skills in drafting a contract will be essential in ensuring that you save your clients, whether you are acting for the employer or the contractor, the likelihood of a dispute. And construction contracts are more likely to have disputes compared to other commercial contracts. When you are drafting, think clearly about risks, risk allocation. If you don't allocate risk properly, then chances are the contract is going to run into dispute quite early, even before the contract runs deeper. I would like to give you a simple example of regulatory approvals. If your contract provides that those approvals are to be acquired by the contractor, say for environmental management or environmental licensing of the project, and similar things that are ordinarily supposed to be borne by the proponent of the project, then chances are this contractor is going to run afoul even before he starts the contract, because you are giving him risks that he cannot weigh. On the other hand, if your contract provides that defects in design and limitation in design are going to be borne by the employer, yet the contract has been designed or the project has been designed by the contractor, then you are giving an employer a risk that you would not be able to cure in any other way. And so risk allocation must be at the back of your mind, and you must allocate it. Don't have this mind that I'm acting for the employer, so I'll try to push as much risk as possible to the contractor, or I'm acting for the contractor, I'll push as much risk as possible to the employer. You must balance them, and you must allocate them using prudential, steps, using experience, using standard of practice. When also drafting, consider application of standard forms, and standard forms are forms like FIDIC, JBCC, NEC. Even locally in East Africa, we have standards. In Kenya, for instance, you have the Joint Building Council, which is basically a contract which was developed by associations of architects, quantity surveyors, civil engineers, mechanical engineers, and I believe in other East African community partner states, there are those kinds of standard forms. So consider using a standard form as opposed to attempting to draft a complex construction contract from the scratch. You are likely to make mistakes, or if you start cherry picking, clauses from one form and another form and trying to build your own new contract, you are likely to run afoul and end up with a donkey with black and white paints and call it a horse. Be careful about that. So when you are deciding what form to choose, again, let this not be as a lawyer going over the internet or leaving this room and saying, oh, we were told we could use standard forms and picking out a form. No, think clearly about what form aligns closely with your client's requirements. Is it FIDIC? Why do you choose FIDIC? Is the contract worth the kind of rigorous administration that FIDIC contracts would require? So choose wisely. Just don't go over and pick that I know there's something called FIDIC, I'll choose this for FIDIC, for a contract whose value is $100,000 or even $1 million, and the cost of administering under FIDIC would be twice the value of the contract itself. Is that a risk you want to take your clients through? The other consideration when choosing what kind of standard or form to use is the pricing arrangement. There are contracts which are fixed sum. For instance, in the construction of a building, we already know the floor space, the kind of finishing, the kind of materials that are going to be used, the number of floors. You can fix the price at the beginning using the bills of quantities. So such contracts are called fixed sum. So when you are choosing the form, you have to check, is this a form which supports fixed sum? Then we have contracts that are of remeasure nature. You can only estimate what is the pricing likely to be, but you may not know. An example is a contract for building a road or for building a pipeline. We might estimate that it will be 100 kilometers of a road, or 25 kilometers of a pipeline, or 180 kilometers of a railway line. But when you come to actual construction, there are factors that could either shorten the length or increase it. Probably there's an anomalous condition that requires the road to go over an hill or bypass a hill. That means you'd be increasing some 5 more kilometers, and this would require compensation. So under such contracts, we have indicative prices in the contract, but the eventual contract sum will be determined based on remeasure. At the end of construction, we take measurement and determine whether we've done 100 kilometers as per the contract, or it's 96 or 105. And so the price difference will have to be paid, or the compensation mechanism. So you have to check, does the form you choose support that kind of arrangement? You also have to check about design responsibility. There are contracts where the employer does the design. The employer has, they are complex, like building a power plant. The employer would at first get a consultant who is going to design, do the feasibility study, and build, and come up with a design. And then the employer will invite contractors, eligible contractors, to compete on that on that design. And so you have to check, does the form you choose align with an employer designed contract or one where the contractor does the design himself, and you allocate responsibilities or risk appropriately. And you also have to check on the value of the contract when choosing a form. Some contracts are too small in value that if you choose a complicated form, the cost of administration is going to be high and it's not worth the value. Well, some contracts are of so much high value that if you choose a simple contract, the administration is going to be inadequate. And so you also have to check that particular, what is the value? And just as an example, in case of FIDIC, there's already a formula of deciding what you are going to use. FIDIC has a whole suite of contracts. The first one there is green contract, which is short form contract, normally used for very simple contracts, normally designed by an employer, not complicated at all. Then you have the red book, which again is a contract designed by the employer, meaning the employer will take any risk in the design. If the design is inadequate or if the construction or functionality fails because of inadequacy in the design, not in workmanship, then the employer will take responsibility and not pass it to the contractor. You have other cases where the contractor will do the design. So that means the contractor is doing both the design and the construction. In that case, if you're using FIDIC, you'll go for the yellow book. But you only go for that yellow book in the case where the contractor will design, construct, and hand over to the employer. When it is complex, and we call them turnkeys, where the contractor is supposed to design, do procurement, construct, and even operate the project for a while, then we use what we call EPC or turn book or silver in the case of FIDIC. Those are just examples on how you do selection of the form. In terms of clauses, again, even if you choose the form, you still have to pay attention to some of these clauses that could lead you into disputes. Milton talked about some of them, so I'll just brush over. One would be precondition. There will be a clause on preconditions to commencement of contract. You already have signed the contract has come into play, but the execution has not started. There are some preconditions. Some of them could include payment of advance payment to enable the contractor to mobilize to the site. There are issues about site handover because construction is not virtual, it's physical. There has to be a particular site where construction is going to happen. The owner of the site is the employer. The contractor needs to have formal handover of the site. And this is important because from the date the site is handed over to the contractor, the employer has no control over that site. Whatever happens on that site is within the hands of the contractor. And that also affects issues like insurance of the construction. The contractor cannot take responsibility for insurance of a site, which is also controlled by the employer and other people. So site handover makes it exclusive in those cases. Then you have regulatory approvals that I talked about earlier. There could be preconditions to commencement. The clause could stipulate that the employer has to provide the following. Yes, please.
We just have like 3 more minutes.
Cynthia, you'll have to bear with me. I'll try to wrap up, but let me try to cover these particular clauses, then I'll just wrap.
Okay, please. Thank you.
Thank you. And so you'd also have to look at the scope of the contract. You have to specify clearly what activities are to be undertaken by each party. The scope has to be well reflected within the contract. Otherwise, a dispute will arise because somebody says that didn't fall within my scope. It's a common observation. That was not within scope, the contractor would say. Then think about variation. Under what circumstances is variation likely to occur, both of either scope or pricing? What is the procedure? How is it supposed to be communicated? And think about statutory requirements in public procurement or public contracts emanating from public procurement. a variation must meet a certain threshold and should not exceed particular threshold. It could be 15 or 25%, depending on jurisdiction. And where you exceed, you must even open up yourself or the parties to criminal prosecution. Contract price, I've talked about whether it's fixed sum or remeasure. You need to specify the contract price or the formula for determining the contract price where you cannot determine it at the beginning. Think about the invoicing procedure, the settlements, because dispute will arise because the contractor is saying that he has not been paid within time. The employer is saying that the invoices are not properly supported. There are no certificates or things like that. So that procedure needs to be well specified. Interest on delayed payments needs to be well captured. And then there are issues of taxes. Who is responsible? What taxes? We have disputes arising because the contractor says the taxes were to be the employer's obligation. So you need to be very specific. Think about subcontracting. If the contract allows for them, how is it going to happen? Are they going to be nominated, which means they are going to be decided on by the employer, or are they going to be local subcontractors who are decided on by the contractor himself? What can be subcontracted, what cannot be subcontracted? Who pays the subcontractor how? How do you manage disputes with subcontractors? Privity of contract. And you will see, if you go online, you could find the principle laid out in the Belgravia case, especially concerning name borrowing clauses in contracts with subcontractors. Think about test on completion and acceptance, because if the tests are not well specified, then how do you know whether the contractor has delivered what was supposed to be delivered? How do you determine? Think about defects liability. How is it captured in contract? What is the period? How do we secure that period? About the retainer sums, which are payable after the defect liability period. How are they to be reduced from the certificates during payments? And when are they supposed to be paid? How do you enforce the defect liability clauses? Think about that. And then the project timelines, quite important. More often, disputes arise because of time. The time of completion is not well captured, it is not well defined, or exceptional events have occurred that have led to delays. There are extension of time with or without compensation. It would be a whole topic to talk about extension of time, but I would simply put it this way, that where an event occurs which was not due to a contractor's fault, is entitled to seek extension of time, meaning additional time to deliver on his obligation. That can come with or without compensation. Where, on the other hand, the contractor delays and no exceptional event occurs or a delay by the employer occurred, then the contractor would still be given extension of time, but that could come with damages. If he exceeds the overall completion period, then the employer could be entitled to delay damages, what we call liquidated damages. Milton already talked about critical path, that you need to check when designing the plan which activities are falling on critical path, meaning that if a delay of impact occurs on any of them, it is going to impact the time for completion. Be careful, even in contracts management, to ensure that time is not at large, meaning at any particular point, we should know that there's a time for completion. If we leave it undecided, then even at the beginning when we are making the contract, we might have time at large, which could disadvantage mainly the employer. Think about termination of contract clauses. What are the circumstances, procedures, consequences? Think about dispute avoidance or management clauses. Forms like FIDIC already have inbuilt dispute adjudication or avoidance clauses. If you are not going to use them, think about these clauses. And you build this by having a proper complex resolution process right at the beginning. Project teams level, let them handle it at expert level. If that fails, escalate it to executive management of the parties through negotiation. If that fails, you could think about mediation by what you call assisted negotiation, probably by an expert or a neutral party. Still, you've not escalated into a dispute. It's still sort of a complaint or a claim level. Think about having a dispute avoidance or adjudication board, especially in complex projects. FIDIC has them, where you have experts in dispute who will be, visiting the project and speaking to the parties from time to time to troubleshoot things that could lead to disputes later. You could think about expert adjudication as well. And finally, you could also think about arbitration mechanisms, which are well built within the contract. Just to observe that when thinking about arbitration, especially with court contracts that also have subcontract provisions, you need to be clear on how disputes under the subcontracts could be handled. Increasingly, disputes with subcontractors directly with employers are a thing now being seen in construction contracts. And some of the cases like Otton and MFCAT services and even Belgravia Properties case will demonstrate to you how these disputes could actually get too complex if they are not well documented. Thank you so much, Cynthia. I know I've not had time to discuss everything, but let me hope my other colleagues will also bring these other things up. But otherwise, thank you.
Yes, thank you so much, Mr. Samuel. Really sorry about the time factor. It's clearly not on our side. The comment sessions are coming in really, really nicely. Douglas is saying thanks for this excellent presentation. Excellent presentation from Ivy. I may not be able to read the questions right now because of the time. Perhaps we'll have a brief Q&A at the end. So without further ado, allow me introduce our next panelist, who is Nicholas Echimu. Nicholas Echimu is a partner at DLA Pipe.
Cynthia, you're muted.
You're muted, Cynthia.
Oh, sorry. I'm really sorry. I don't know where I muted the mic from. I said that there's been very good comments from the comment section, but due to the time factor, we may not be able to ask the questions. There's been so many questions coming in for you, Mr. Amol. Due to the time factor, we may have to ask them at the end. So without further ado, allow me to introduce our next panelist, who is Mr. Nicholas Echimu. Mr. Nicholas Echimu is a partner at S&L Advocates, DLA Piper. He has a vast experience on litigation and arbitration, and his key focus areas are construction and infrastructure law. Without taking any more time, Mr. Echimu, you're welcome for this. You can take the floor. Thank you. Unfortunately, you may have only 10 minutes. So okay. I'm really sorry, but that's the time you have.
Not a problem. I can see probably this needed a lot more time than we've been allotted, but it's perfectly fine. Beauty about it is that most of us are speaking, quite closely about, similar things, so it shouldn't be so much of a problem. I have a quick presentation. I will choose to, basically go to maybe 1 or 2 slides towards the bottom. I'll not spend a lot of time on the beginning slides. I'll just talk about the frameworks for dispute resolution. And then I think really what is important is just for me to share my experience of about 25 years managing construction contracts and being in the deep of things. So ladies and gentlemen, thank you very much for joining. Basically, in construction, we have a scale of escalation when it comes to disputes. We have what Milton talked about, which is basically the owner's engineer being the first point of call, being the neutral person on the project, and making sure the contractor is doing exactly what the employer expects to have. But in the event that you're not happy with that, sometimes there are specific things that come up in construction that lend themselves to adjudication. And this can be, by submission to an expert on a particular thing. If it's an electromechanical dispute, you're better off looking for an electromechanical engineer to be able to advise whether, the installation is correct on the power plant or not, other than getting a judge who's practiced criminal law and things like that. We've also seen a lot of contracts going to litigation, but those are really low value contracts. If you talk about large infrastructure projects anywhere in the world, most people will defer to the standard forms that my brother Amol spoke about, which is basically FIDIC and any other NAC and all those kind of forms. That is not to say that parties cannot lend themselves to courts. We are currently doing a dispute, in the court of law in Uganda, arising from a construction contract. But where you choose arbitration, for example, then chances are you'll end up with, arbitration as your dispute resolution mechanism. So we'll not speak so much about each of those facets, but I think I'll just take you quickly to the role of arbitration institutions generally in dispute resolution involving contracts. We have case administration, which is basically the efficient conduct of arbitral proceedings. And each of the respective arbitration centers that we'll talk about have their own ways of managing case administration. Once you log in your case and then you have a matter number and all that, chances are then you'll now move to the second level, which is basically either appointing arbitrators, or if you choose to do mediation and conciliation, depending on which regional center you've gone to, you could choose to start with mediation or conciliation before you head to arbitration. Then we also have then the dispute resolution services, which is basically arbitration and mediation or conciliation support. Different centers have different procedural rules. Different centers do different professional training, and different centers have different facilities that we rely on when it comes to dispute resolution. I'll quickly speak about the four. We'll assume that all your courts of judicature in your respective countries, depending on the threshold of the claim, would easily lend themselves to be able to handle your litigation matters. But where you have an arbitration clause, for example, in Uganda, if you file in court, chances are it will be dismissed, and then you will be referred back to arbitration. The non-regional centers in Eastern Africa or in Africa that lend themselves to our region of the world are the Nairobi Center for International Arbitration, set up by by an act of parliament in Kenya. Their main legal system is common law leaning, and they do arbitration and mediation. Then you also have the Kigali International Arbitration Center, largely inspired by ancestral model rules. They lend themselves to civil law, and they do arbitration and mediation. Then you also have the Mauritius International Arbitration Center. They use ancestral model rules, and they were set up by an act of parliament, and they are very closely affiliated to the London Court of International Arbitration. They are hybrid because in Mauritius they speak both English and French. So they are actually, dual, and they can, depending on the choice of law you take, they're able to handle both. They do arbitration, mediation, and conciliation. Then for those who may not know, under the ESCJ treaty, under particularly Article 32, it is agreed that either you can have arbitration in the court, either instituted by a treaty party, which is either the institution of the ESCJ, or a country that's a member state, or even two parties, private parties, commercial parties can choose to adopt the ESCJ arbitration rules as the rules that will guide them when they have a dispute. And this only relates to arbitration. I will not dwell on this so much because I'm going to share the slides, but it basically covers the nuances, who appoints, what kind of things are there, confidentiality cuts across all of them. They all, I think the first three have model arbitration clauses. Their respective secretariats appoint the arbitrators. Most of them have at least a panel of distinguished arbitrators, and you can choose from that panel. But where you don't agree at all, then the head of the secretariat or the president of that particular arbitration institution would have the right to choose. Then the seat is normally in the center, in the host country of the center, if you don't agree. But if you choose to go to a more fancy island like Zanzibar, you can always choose to take the arbitrators there. Maybe the one thing I can also say is that really for arbitration, you have a fair sense of control, because you can choose to say, okay, we're going to sit for 1 week, we want to be heard, you're going to give us the award within a short period of time. And whatever comes out of arbitration in dispute resolution involving construction law is always final and binding on the parties. And you will seek to enforce in the local courts within your country any such award that is rendered by any of these institutions. So I will not go very deep into what my other colleagues have already said. I think what I just need to share with you is what you just need to know to be on top of the game, gathered from experience. I think for you to be able to be a good construction lawyer, you need to understand the industry you're operating in. You need to know that engineers and sponsors are the people or the owners of the project or the employer, or even financiers sometimes. All these people will rely on you to guide on the most suited contract type for their project. And depending on how you want to, basically allocate risk, responsibilities, rewards, and all that, it may be entirely up to you to be able to guide on what kind of form is best suited for that particular situation. The second thing that I would encourage you is that understand the sector in which the project falls. Ask yourself, is it a power station? You probably need to understand everything that goes with power and electricity. Is it a transmission line or a generation unit? Is it an airport? Because some of these things have additional regulatory nuances that you need to appraise yourself about. I always tell people that when I interact with people, they ask me whether I was first an engineer before I became a lawyer, or whether I am an engineer or I became an engineer after being a lawyer. But with over 20 years of doing the same thing, you get to understand the language of the industry, understand the nuances of the sector, and then understand how best you can actually give advice. The other thing I can advise is be involved from the start. If you're involved from the beginning of the negotiations, you probably take down the minutes of negotiations, you review the contract with the client, you spot the risks that are inbuilt, you will be best placed to be able to advise on the, on the implementation of the project. It's very complicated when you come at the tail end of a project where there's a dispute and they're telling you, okay, now advise or represent us. I can tell you, you will struggle. I had a dispute where I told the client, okay, bring me all the correspondences you had. And when I showed up in my office, which is not very small by any measure, the whole office was full of boxes. Then you figure out, okay, where do I start from? What do I do? What do I leave? What do I read? What is not important? So sometimes when you're there from the beginning, it makes a difference. It helps you on the learning curve. And it basically helps you understand the nuances. Then just understand that whatever you do, things will go wrong. If you are doing a project, hydropower project, 600 megawatts, construction period of 5-6 years, there is no way, whatever you do, you can never anticipate every risk. Something will go wrong. My advice is be a peacemaker, work to find solutions, because every day there will be something that lends itself to a dispute. And you could be forever engrossed in quarrel through and through, and you will not be able to develop the project that you're thinking about. Milton told you about data and documentation. In construction, documentation is everything. When the weather is bad, please write. When the weather is good, please write. When your invoice is delayed, please write, because that's the only thing that an arbitration panel will look at to be able to determine whether you are entitled to be lent additional time, or whether you actually have to be paid for the delay because it was an act of God. You would be shocked that you may even have to have meteorological data on a weekly basis to prove that during a particular time of construction, the weather was so bad that you could not work 24 hours as you had anticipated. We've seen this come through in some of the projects we worked on. And the one thing you can do is to try and claim for more time for delays at the end of a 5-year period. And you're talking about things that happened in year 2 of construction. So unless you have documentation, you'll have a problem. Then you need to master and understand the dispute resolution stages. Most of these contracts will have, expert adjudication. They will have the owner's engineer decisions. You will have the dispute adjudication board, sometimes set up at the beginning of the construction to deal with day-to-day issues as they go along. Or if you even escalate to the CEOs or the MDs or whatever, and it still doesn't work, you end up in arbitration. So you just need to understand what comes first and just try to follow the hierarchy of escalation. And then as a lawyer, you need to understand your enforcement mechanisms. At the end of the day, once you've gone through dispute resolution, what exactly do you want for your clients? Do you want your client to get paid if you're working for the contractor? Do you want a product if you're working for the employer? Some of those things are things that you need to be thinking through as you plan on what you do with your disputes. I just thought I should share a bit of my own personal experience. I had the singular privilege of working on a very large project in Uganda, 600 megawatts hydropower. We thought we would do it in 5 years with delays and everything. We did it in about 9 years. And I mean, I cannot tell you how much, learning I took from that project. And it's something that I use a lot to train young lawyers who work with me. But I just thought I should just pick a few things that I thought went wrong and got us to the kind of situation where we are. But thankfully, in all that, much as we had fights and all that, nobody ended up in arbitration. We were able to work out our differences. And I can tell you, once the ribbon was cut and the turbines were turned on, everybody is very excited. Nobody even knows that we shouted at the top of our voices and nearly stood on tables trying to resolve disputes. I think one of the things I can talk about is the challenge you can have in a project is to have a non-comprehensive project design due to either negligence of the construction.
We've run out of time totally.
Oh, okay.
Sorry. You can just finish within 2
Okay, so
minutes.
basically,
Please,
if you look
please give him a minute. Please give him a minute.
at non-comprehensive project designs cause problems, failure of the parties to comprehend what rights, responsibilities, and obligations arise. For example, this was a lump sum contract. At some point, we were being told, because you have a BOQ, bills of quantities, no, we are going to count the amount of poles or pylons that you built over a 300-kilometer stretch. Setting unrealistic delivery times, unforeseen circumstances like COVID cost us 2 years. Failure of the employer to hand over sites quickly cost us 3 years of delay. Cultural prejudices, if you want to see a fight, have a Chinese contractor and then you have a European consultant. They will never agree on anything because all of them believe they are top on their game. Poor costing of projects lead to disputes. Poor scoping of works. There are certain things which are not put in the employer's requirements, and then the employer insists that if you have to build a door, you should expect that there should have been a door frame. But if you didn't put it there, I didn't cost for it as a contractor. So what do I do? Prejudice owners, engineers, and then sometimes you have just way too many people overseeing a project. In this particular project, we had the owners engineer, we had a panel of experts, we had the project steering committee, we had the Ministry of Energy, and then you had 2 implementing agencies. You can buy me a drink one day and I'll tell you how it ended, but it cost us 9 years because of the various, people we had to deal with. Thank you very much, ladies and gentlemen. I wish you the very best, and I'll wait for any questions at the end. Thank you.
Yes, thank you so much, Mr. Chiu. We're really sorry. Time is really, really not on our side. Kevin says, excellent presentation. Thank you very much. Most people are saying excellent presentation. Thank you so much, Mr. Chimu. It's been a pleasure. Let me just quickly go to our next, since we've really, really run out of time. Dr. Kimari. Dr. Kimari is going to present on risk mitigation strategies. Dr. Kimari, since we have like only 10 minutes or even less, you could just quickly run through. Dr. Kimari is an advocate of the High Court of Kenya, chartered arbitrator, certified secretary, certified public accountant, and is also a court annexed mediator. She holds an LLM and she holds both an LLM and LLB from the University of Nairobi and has broad experience in commercial law, aviation, procurement, employment, and legal audits. She's also a partner at KM Advocates, KM Partners. Please, you're welcome. You can take us through. Thank you so much.
Thank you very much. That has taken a while. I just noted that as we kept on going on through the construction contracts, each presenter actually picked out all the risk areas that we're presenting on this specific afternoon. Just to clarify, currently I'm at the Ombudsman. I'm the advisor to the Ombudsman, so I'm not in active litigation. Let me go straight to it. It is a privilege to contribute to this vital conversation on risk mitigation strategies in the construction industry. I'll go directly to the various risks. I'll look at them in three perspectives. Allow me to share that with you very fast. Give me just 1 minute to have the slides on. Lovely. I'm hoping you're getting that. As has been said by the previous presenters, construction sector is inherently high risk. It is wide. Most of us look at construction from the point of view that it's simply the simple ones, the houses, the flats, are not realizing construction is actually extremely big and hence has major risks. Our first presenter, Milton, talked on the aspect of having one specific contractor actually managing the entire construction project, not realizing that there are instances whereby you also want to share out that specific risk, because the bigger the project, then the higher the risk that you have on that specific one. Perhaps the first risk that we'd look at is the legal and regulatory risks. I'll pick them out very fast. The first one would be the permitting and the licenses of all construction projects. We find that delays or denials of necessary permits can halt a project. In Kenya, obtaining a construction permit requires securing at least 4 mandatory approvals. Talk about the architectural plan approval, the structural plan approval, an environmental impact assessment license, and also a project registration with our National Construction Authority, which I merely would assume or would believe that that runs across the entire East African community. How would we go around mitigating this, involving early engagement with the regulatory bodies, due diligence on applicable laws and regulations, and also potentially engaging with various councils that are extremely vast with this area of environment and land use, and also on construction law. The second one would be on the contractual risks. We very well know that ambiguities and gaps and unfair clauses in contracts can lead to disputes. Specific contractual risks in construction projects will come in various forms. As stated by the last presenter, Nicholas, even talked about the weather patterns. Weathers are factors that could actually or would potentially stall a construction project and actually give rise to very heavy damages on the same. We'll find that most construction projects have actually been stalled, not by anything else other than by the aspects of simple weather patterns in that specific area. So it goes without saying that that becomes a very common or a very specific area to look at as you're closing them within the contract or within the contractual contract. I'm still moving the slide. Sorry, I hope the slides are moving from the end. I'm trying to do that. Perhaps I move on. The second one would be the scope creep. This refers to the uncontrolled expansion of the project scope beyond the initial agreement. It can involve the design changes, the unexpected site conditions, or even additional requests from stakeholders, leading to increased costs and also the complexity of that specific project, noting that it has now metamorphosized from what it was before to something else that you had not prearranged. The aspects of delay in itself becomes a common denominator risk in all construction projects, because this is where the owner of the project or everybody involved in this specific project gets their money from. The adage that time is money is actually very real in construction projects. The third one would be the financial disputes. Financial risk in construction projects can arise from various issues such as payment disputes, material cost fluctuations, or incorrect cost estimates. This leads to major financial losses, cash flow problems, or even potential litigation. As earlier brought out, you'll find that most of the cases that come up zero in on the aspects of the costing on that specific project. Notwithstanding the aspect of health and safety hazards that would also indirectly relate or lead to financial losses that would arise. Construction sites are inherently hazardous environments, and the safety-related risks are significant concerns. Accident, injuries, and non-compliance with safety regulations can result in financial losses, legal liabilities, and potential project delays. We have the aspect of the subcontractor defaults. I know most would prefer to actually run with it, but it goes without saying that construction has various lives within it. Let me call it lives or the phases within it that require the main contractor to have subcontractors to deal with the specific areas of that specific project. So they'll involve multiple subcontractors, and the default or a failure of a subcontractor will have significant impact on the completion of the entire construction, again, leading to delays, increased costs, and potential legal issues. We have the aspects that have been discussed in length, contractual disputes that are related to contract interpretation, the scope of work or payment terms that may arise during the project life cycle. Like you could hear the aspects of the BQs that now, since you've not fully discharged this specific contract, can we then discuss on the aspects of partial in relation to whatever it is that has already been constructed. That in itself increases the costs and also gives rise to the potential of suits. Poorly defined contracts would give rise to incomplete or poorly drafted contracts that can increase the risk of disputes, delays, potential legal actions, etc. I think that has already been spoken to when we said, or when Amol talked about the need to have standard contracts and gave an example of the FIDIC contracts. And I think as that was going on, we could actually relate, most of us could relate to that, dealing with, or in reference to some of the projects that we've seen in the country that have actually picked out some of the books that are under the FIDIC. We also have the material pricing. Due to the aspects of fluctuations in material pricing under the contractual, we need to have a specific clause that brings out that on the impact of the project. That in itself, remember, would increase the budget, ideally increase the total budget of the project from the point that it began to when it's actually coming to an end, due to the need for additional funding. We have another aspect of lack of skilled labor. Shortages or disruption in skilled labor can lead to delays, increased costs, and also potential project setbacks. We keep on talking about lack of employment, that we have so many people that we can employ in various projects. But when the rubber meets the road, we find that the people that we are having coming to projects to work do not actually have the technical skill or the ample skill to actually manage to carry out that specific contract to fruition. So in most cases, there's a lot of exodus or export of labor to come in and manage certain contracts, certain big contracts that would have been run more affordably if we had used local labor. Lastly, on the aspect of the contractual risk is the inconsistencies. Changes in project goals or timelines by subcontractors or clients can disrupt project schedules and impact other parts of the project. By the time we were starting, we had this beautiful Gantt chart that provided the project or the activities that we are carrying out vis-a-vis the time. By the time we are finishing, we're already 2 years past the completion date, and nobody sits fast to think about the cost that we've actually endured and which needs now to be recouped. By the time you're discussing that, it turns out to be a legal suit. Now that I was looking at the various risks and strategies to mitigate, perhaps I can go directly on that specific one. How would you mitigate then the contractual ones? We have to come up with clear and well-defined contracts. We have to define that scope, the payment terms, the dispute resolution mechanism, and find out how we are going to allocate the risk within that specific contract. The second aspect is effective risk management. Implement a comprehensive risk management process that identifies, assesses, and mitigates potential risk throughout the entire project lifecycle. We must have strong project management ensure effective project management practices that include clear communication, documentation, and change management aspect is in turn. Safety protocols that cannot be belabored. We have to implement robust safety protocols and ensure compliance with safety regulations to minimize the risk of accidents and injuries. Perhaps not the last, but what I would have as the last in this presentation is supplier relationship management. We must establish a strong relationship with suppliers and subcontractors to ensure timely delivery of materials and services. You at site, you're waiting for certain materials. Some have come, others have not come, but you required both of them to actually commence the program. You're not commencing because there's somebody who's not managed to bring in. Meticulous contract drafting and review by legal professionals. And now that we hear Nicholas is an expert with over 20 years, those are the kind of people that you require now to take these specific contracts to, so that they can review that for you and ensure that it's in itself, it has adopted the various clauses that minimizes the risk and hence works on the aspects of delay. The second aspect or the second risk would fall on the technical risk. Under technical risk, you're looking at aspects of the design flow, errors or omissions in designs that can lead to costly rework of the entire program. How would you mitigate that? Undertake a robust design review and the processes, engage peer reviews, engage experienced design teams and potentially design build contracts to transfer that design risk. Geotechnical risks.
Doctor, you haven't been
Yes?
moving slides.
Oh, sorry.
The slide, yes. And we have like a bit 3 more minutes.
Can you see my slide?
Doctor, I think just speak through, what you're seeing on your side. Since you'll share the slides, then members can from there, yeah.
Thank you. Apologies about that. Let me just move on very fast. Okay, geotechnical risks. Unforeseen ground conditions can cause delays and also cost overruns. So we have to mitigate that by undertaking comprehensive ground investigations, contingency planning, and appropriate contractual clauses to address unforeseen physical conditions. We have the aspects of material and equipment failure, still under the technical risk aspect. Undertake to carry out quality issues or breakdowns, carry out rigorous control on materials, get or engage reputable suppliers, have proper maintenance people, and the plans for those equipments, and also have backup strategies. That is going to come in handy. We're on the fourth one on financial risks. Under financial risk, we have the aspect of cost overruns, unforeseen expenses that can quickly deplete your budgets. How do you mitigate these? Undertake to have accurate cost estimation, contingency budgets, a robust cost control system, and careful management of variations and change orders. You have to be very specific. Please look at it, have a matrix on the same, and keep on checking. Be at it on a day-to-day basis. On cash flow issues, delays in payments or unexpected expenses can actually cripple that specific project. So mitigate this by ensuring that there's a clear payment schedule. As I bring this out, I'm hoping you're picking it out to ensure that the clauses clearly provide that. Clear payment schedules that involve timely invoicing, robust cash flow forecasting, and also a strong financial management background. The aspect of currency, we've had a problem or a risk of currency fluctuations where you're dealing with international projects. This will impact not only the material, but also the subcontractor payments. So how do you mitigate it? Ensure you hedge, undertake to undertake the hedging strategies, pick up the currency clauses in contracts, and also source for local materials and labors, which will not be interpreted using the international currency. The aspect of operational risk, I already talked about the labor shortages or the productivity issues, which can cause your delay. We have to mitigate this through realistic labor planning, competitive wages, good working conditions, training programs, and also understanding the law of your jurisdiction to find out how much or how many manpower you can actually export to the country. We have the aspect of supply chain disruptions. This is delays in material delivery. Please ensure you diversify supply chains, undertake early procurement, have some buffer stock, and also ensure that there's clear contractual terms with the suppliers on aspects of supplies. Force majeure events that has already been talked about, the natural disasters aspect, pandemics, political unrest, like I know this would happen in instances where we are having certain national events, perhaps in a country. So mitigation, ensure we draft proper force majeure clauses in contracts and the contingency plans and have appropriate insurance coverage. The last one perhaps that would pick out would be the reputational risk. I think I never had that specific one. This is where, as we are moving on with the specific contracts or construction contract, there's negative public perception due to safety incidents, environmental damage, or even ethical breaches. How we do mitigate this? Please ensure that even as you discuss the same, have strong CSR policies, transparent communication, and also proactive crisis management. Good, and time moving fast. What is the aspect? The second aspect of my presentation was on proactive risk response strategies. Once we've identified the risk and needs, we now need to have a planned response. This will typically fall into 4 categories. The first one is avoidance. Eliminate the risk altogether, e.g., you may change the project scope or even that design to avoid a high risk area. As an advocate, this is an area you're able to actually advise so far so that when you look at the pros and cons, you can actually tell that the specific client, due to these changes that we're having, perhaps you can totally do away with it. Even the cost of actually breaching the contract might actually be lower than the cost of totally doing away with this specific project. The second one is transference. Let's shift the risk to another party, often through contracts or even insurance, e.g., let's agree on liquidated damages clauses, performance bonds, professional indemnity insurance for me as an advocate, etc. How did I pick that? I have to take steps to reduce the likelihood or impact of the risk, e.g., by implementing a strict safety protocol and conducting thorough due diligence. The third one is acceptance, acknowledging the risk and deciding to bear the potential consequences. This is usually for those low impact, low likelihood risks, often with a contingency plan. And lastly, leveraging technology for risk monitoring and management. Technology plays a transformative role in modern risk mitigation, moving from reactive responses to proactive management. Perhaps the first one would be the contract management software, the CMS, which is a critical tool, especially in construction. What it does is it helps us to centralize. It provides a single secure location for all our contract documents, amendments, and also communication. My previous speakers have spoken about documentation. We need to have this specific trail. This significantly reduces the risk.
Unfortunately, we are way out of time. I'm sorry. Okay, just 2 minutes for you to finish.
Okay.
I'm sorry.
Or conflicting versions, which are common sources of disputes. It also helps with critical updates when you want, which would help you to know certain things that are coming up so that you don't miss your deadlines, which would lead to breaches or even forfeiture of rights. It helps with the clauses analysis and also compliance, the change order management, the dispute prevention and resolution, and also the risk reporting and analytics. The second tool, perhaps, and technology would be the project management information system. I'm hoping you're going to look at the slides that I'm going to send. Integrate various project aspects, including scheduling, budgeting, and also resource management. They help you to identify deviations from the plan very early on, allowing for timely corrective action. We also have what the previous speaker, I think, discussed, the building information modeling, which is used for clash detection and during the design, identifying potential conflicts before construction, thereby mitigating rework risks. And lastly, we have the data analytics and also the artificial intelligence, which would help you on the predictive analytics, the early warning systems, the legal research and clause review, and lastly, on the geospatial information system. Perhaps in conclusion, having dealt with various disputes as a quarter next mediator in my country, I would be stating that effective risk mitigation is not optional. It is a legal obligation and a strategic imperative. In construction law, our role as advocates extends beyond dispute resolution to shaping preventive strategies that enhance project certainty and accountability. By integrating legal insights, proactive planning, and cutting-edge technology, we can create a more resilient, compliant, and successful construction industry. Thank you.
Thank you so much, Doctor. And unfortunately, the discussion was really, really good. It's just the time. But thank you so much for keeping time. We'll just have our last panelist. And perhaps, Mr. Okoth, we might be having only like 5 minutes for this. I don't know, because we just wanted to put in some time for questions. We have a few questions on from the audience. Mr. Okoth is going to discuss leveraging development finance and investment structures to minimize construction disputes. And he is a seasoned legal expert with over 25 years of experience in legal management, corporate law, arbitration, and project finance. He has advised on major infrastructural projects across East Africa and presented Kenya in international forums. He is currently the chair of this East African Construction Law Committee. Mr. Okoth, you're welcome. Please take the floor. You have strictly 5 minutes. I'm really sorry, but thank you so much.
You can hear me clearly?
Yes, we can hear you clearly.
Okay. It's very unfortunate and also quite a blessing to speak after such a rich mass of information has come. Nonetheless, I shall take you through a very interesting topic where we are trying to see how to leverage development finance and investment structures to minimize construction disputes. And this is in relation to cross-border disputes. So what I'll be looking at is a few of what we call cross-border construction projects. Since I have 5 minutes, we shall not go into them. I shall just mention them. Then I'll tell you who the development finance institutions in the region generally are, how they help to reduce investment disputes or construction disputes rather. I want to go into strategic types of investment structures, but that may not be possible. So that would then have led us to a very interesting discussion on what key legal instruments can help prevent construction disputes. But that was amply covered by Milton and Amol. So basically, we're talking about projects like the Kenya-Tanzania Railway, the standard gauge railway. I can't go into too much of that, but it's ongoing. The Lamu Port, South Sudan and Ethiopia corridor, it's a transport corridor, also still undergoing, it's still in the process. There's various Nile Basin energy initiatives that cover Ethiopia, Uganda, Tanzania, Rwanda, Kenya. So that's quite large. There's the Addis Ababa Djibouti Railway, there's the East African crude oil pipeline that is generally between Uganda and Tanzania, and the Kigali-Bagali transmission line between Rwanda and Uganda. These are usually financed by, let's see, the African Development Bank, World Bank, International Fund for Agricultural Development, European Investment Bank, Islamic Development Bank, and of late the Exim Bank of China. So those are some of the development finance institutions which have in the course of time. Oh, sorry, I'm trying to take you fast through in a structured manner. These people or these institutions have actually helped us kind of standardize how we do things because we have political risks, we have regulatory differences between countries, and bringing in this systemic kind of these kind of systems among all member states helps to reduce disputes, especially when it comes to one thing no one has mentioned in depth, which is the political risk as an issue under construction contracts. What might have been mentioned, the operational parts were mentioned, but what might have been left out was that I think all members of the EAC are also members of COMESA, and under COMESA we have the African Trade and Investment Agency, which is a body of COMESA which actually deals with political risk. So if you want your construction to actually see the light of day, especially if it runs across 5 jurisdictions, you might want to think about that as an option. Obviously, such structured investment in construction has very good benefits, such as you reduce risks in all aspects of construction. There's clarity in governance in terms of the kinds of special purpose vehicles or construction methods to be used. There's attractiveness of the project to financiers. And obviously, it makes sure all the processes are aligned with local laws. So you do not run the risk of being at cross purposes with any of your partners. I was rushing through some of those just to get to this part where I'm trying to project how key legal instruments within the construction management process can reduce risk. A proper project agreement with clearly defined obligations reduces risk. Financing agreements with clearly established responsibilities and repayment terms reduces disputes. Concession agreements, these come into play very well into PPPs, which most of these cross-border projects are. Clarify issues of tenure rights and termination of obligations. Stakeholders agreements clearly state out what every person should do within the structure of the organizations that run the construction. So if everyone has clear duties, you don't run the risk of going into conflict. I'm not going to go into a case example right now, but this has been spoken about before very well, from Nicholas to Hamilton to Milton. What are the practical tips for lawyers who want to advise on cross-border construction matters? Firstly, understand the regulatory landscape of the region, not just of one country, but of the region. I want to explain that. Secondly, this was already said by Nicholas, build dispute avoidance into contracts, and that has already been explained. 3, negotiate government support agreements. This basically is trying to make sure that you are regulatorily compliant. Make sure that you do not fall foul of, say, the National Construction Authority of any of those countries, because that would literally stall projects, as Dr. Ari has just mentioned. 4, never start a project before knowing where the money is coming from in its entirety. We like calling them turnkey projects and all, but we have seen, and there are too many to mention. I have a list, but no time to go through any of them. We have white elephants in all our countries, all our jurisdictions that have cost us a lot. And they still continue costing us because some of them are not even completed yet. Nicholas spoke about green financing. No, was it Nicholas or Hamilton? More, yes. There are trending issues. We are going digital, we are going AI, we are going global. Borders are of less and less importance nowadays. And if we can grasp emerging trends, then we can also seize the opportunities that come with them. I hope I'm not making it too fast. Why are lawyers key to dispute-free projects? Lawyers are strategic advisors. Lawyers are your partners in the construction process. Lawyers are not just there to make sure the J's are dotted and the T's are crossed. We are there to minimize wastage. We are there to optimize efficiency. We are there to make sure that not only your direct client, but everyone concerned in the construction has a sum outcome. Everybody is happy. We are good in, we are vital to construction projects because we can design resilient contractual frameworks, and we are quite good at this, especially the panel that we've had today, which will be able to, in most cases, secure both the financial and technical aspects and cause a marriage between those to give an outcome that is pleasing to all. I've rushed this and my head is still reeling from the lack of examples. Forgive me, I will share this presentation. In conclusion, what we need to take out of this is that for us to leverage on cross-border dispute avoidance, we must be able to understand and navigate the various regulatory requirements among the different parties or the different jurisdictions. You must come out of this knowing that you build collaborative relationships, especially with your cohorts in different countries, and this builds both your social and professional circles. And then lastly, there's this statement which would have been best in context if we had gone through the case law. The best construction lawyer is not the one who wins the case in court, but the one who ensures the case never gets there. The reason this is a very important quote is because if you start building the LAPSET project in 1986, or let's say 2004, and because of delays caused by regulatory issues, it is still not complete in 2024. The opportunity cost of not having done that in the last 10 years cannot even be estimated. It's exponential, considering the cost of materials, the cost of labor, the cost of everything. It's just exponential. I hope this has made a little bit of an impact in understanding cross-border dispute avoidance. I really rushed this one. And that's it. Back to you.
Thank you so much, Mr. Okoth. I'm really sorry about the time factor. In fact, there's so many comments about the time. Someone is saying, Hiram is saying that each of the presenters ought to have been given an hour to do justice to the presentations. Perhaps for now, we'll go straight to the questions. I liked what you said, Mr. Okoth, about the good lawyer is not the one who successfully litigates a matter in court, but ensures that the dispute never gets to the courtroom. So that is really, really insightful. Most of the questions that I have are, there's one general question about which, someone is asking that which school or which institution offers construction law training? Perhaps one of the panelists can answer that. There's the other question that is directly addressed to Mr. Amol on mutual extension of time. Can a contractor claim for idle equipment or labor during that period? During the period of extension of time? And then there's also the other question on, let me just check. I think I've lost some of the questions. Oh yeah, there's also the other one, and I guess it's also addressed to the same panelists. Mr. Amol, can the employer be held liable for work done by contractor, allegedly based on unwritten agreement? Employer is arguing that they had not authorized the contractor to carry out the work for which they are claiming payment. So that's the other question. After the answers, then we will give each panelist time to do their parting shots. After the parting shots, then we'll close. Yes. So, Mr. Amol, the floor is yours. Please, you can answer those questions.
Refresh me on that first question, sorry.
On the first question was on mutual extension of time. Let me just get it.
Even as you get that,
Yeah.
let me address the second question. We've tried on the question and answer function to answer as many questions as we can, but on the question of whether an employer can be compelled to compensate a contractor for work based on unwritten agreement, I would want to understand it from two contexts. Either there's an initial construction contract which has authorized the contractor to proceed with the works, and in the course of execution of work, there are oral instructions that are issued which were not covered within the written contract, and the contractor wants to be compensated for doing that work. Or a case where the work is actually being executed based purely on oral agreement. I think the contract law has already specified on the threshold for having a written contract. In Kenya, for instance, a contract whose value is over 200,000 ought to be in writing. Of course, that doesn't mean if its work is done, you cannot be compensated. There are other ways of proving that you had a contract and you are able to execute. There'll be communication somewhere, even without a written contract. On the other hand, which is the more common situation within now a formal construction arrangement, you have a contractor who has a contract, who has a defined scope of work. In the course of doing the work, then some oral instructions are given by the project manager or somebody supervising, or one of the professionals, the civil engineer or the architect, tells him to vary or do some particular work. It is not documented, and he goes to execute it. It becomes problematic because unless the contract allows for that, the contract would have provided for change management and such kind of variations and instruction. There would be a site book. As a prudent contractor, you maintain a site book in which when a professional visits and they issue instructions, you ask them to note it within that book so that you execute it based on what they've written there. If there's no such a book, if these instructions are not in writing and the contractor executes them, then as to whether he can claim depends on what happens thereafter. Does the employer acknowledge that the contractor has done that particular work? Are there subsequent communications where the contractor says, I did this work based on oral instruction, and here it is, and the employer has accepted those work? So I think the law would be fair. This is where the equity comes in, and equitable remedies will apply to that contract.
Thank you.
Did you get the first question?
Yes, the first one was, yes. You have explained a mutual extension of time. Can a contractor claim for idle equipment or labor during this period? Yeah, that's the question.
Thank you. One, there's really nothing like mutual extension of time. It's really not mutual. It's a function of the contract and a function of, of this process, that if an event occurs and an extension of time is sought, then it is going to be evaluated by the contract or the project manager to determine whether the contractor is entitled or not. And if the contractor is entitled, is it tied with compensation or not? So it's the risk events that would entitle one to extension of time. What caused the risk event? Is it something beyond the contractor's control? Is it attributable to the employer? And not every extension of time will lead to compensation. Some do not have compensation attached. But where compensation is assessed, then it is up to the contractor to justify what constitute compensation. So if it's idle equipment, the contractor would be able to demonstrate that if there was no delay, then he would have finished that particular portion or activity and moved those equipment to another project. But if these are equipment that are supposed to be on the project from the beginning to the end, they will be required for all the activities falling on critical path, then I don't see how idling is going to be charged, under such circumstances. But eventually, the contractor is able to build. There's a mechanism, there's a formula for determining what would be due where extension of time occurs. Thank you.
Thank you so much, Mr. Amol. The other question is addressed to Mr. Chimu from Godfrey. He says, kindly address us on the impact of the dissolution of UNRA to the construction sector. Is this something we should be keen at whole drafting construction contracts? Then the other question is addressed to Dr. Kimari. Can non-compliance with the funder's requirements be considered a key risk in construction? For example, in case the contractor fails to comply with the environmental requirements set by the funding bank. Perhaps also before you go out, Mr. Amol, perhaps you could address the audience on where someone was asking where they can get the training on construction law, from which school in East Africa or anything of the sort. Thank you.
Is Nicholas going first?
Yeah, if
No,
you
you
don't
can
mind,
go first. Oh, okay. It's okay.
if you don't mind, let me go first because unfortunately
Yes.
I have to actually key out. I was supposed to be
Okay.
left at 4. Thank
Yes.
you very much, Godfrey. I've seen your question. The dissolution of UNRA. I mean, what's the impact of the dissolution of UNRA to the construction sector? I can confirm to you that there's a lot of disorganization at this point in time because it was a single big unit that had very many running contracts. And the situation is compounded by the fact that not every employee of UNRA is actually getting absorbed in the Ministry of Works. So just managing the contracts alone is becoming very problematic. Some of them already had interim payment certificates that had been submitted to UNRA, which you now have to resubmit to the Ministry of Works. I can tell you from purely talking to clients of mine who were contractors to UNRA, they're struggling quite a bit. But I don't think that entails changing anything in the drafting of the contracts because normally most of these contracts will specify a party and their assignees or transferees. So when you sign a contract, you know that at some point it could actually be turned over to somebody, provided the parties agree, or it's a matter of change in law. So UNRA has been dissolved by an act of parliament, and all its rights and liabilities and obligations were devolved to the Ministry of Works and Transport. So that's really by operation of law. So there's really nothing you should be doing in the context of the contract. The management of the contract and the works that are ongoing, neither here nor there, but we're hoping that, with time, everybody's going to find their feet, especially once the ministry has taken on enough personnel to be able to actually review these contracts and then get back to, project management. Thank you very much. And Cynthia, with that, I really request that you allow me sign off. It's been a pleasure talking to all of you. And I'm really hoping that, the few nuggets of what I think maybe wisdom has also impacted on you. I never went to study construction law. It's just that my clients tended to be construction companies and project clients. So it was really a matter of default. But yes, I know that Milton can talk about schools because they went to a very,
Yes.
very good one. Yeah, thank you very much.
Thank you so much. It's been a pleasure.
Okay, bye-bye.
Yeah. So Dr. Kimari, you can also answer. There's a question that was addressed directly to you. If you could answer, then we will go into the individual panelists giving their parting shots so that we can have our closing remarks after. Dr. Kimari, are you there?
Cynthia, kindly repeat the question.
Oh my God. Okay, let me just look for the question again. I had jumped off of it. Yeah, the question is, can non-compliance with the funders' requirements be considered a key risk in construction? For example, in case the contractor fails to comply with the environmental requirements set by the funding bank. That's the question.
And non-compliance with the non-funders requirement.
Yes, be considered a key risk in construction. The funders.
Yes, it will, because remember, from the aspects of drafting of that specific contract, those are the key things that we need to have within the clauses. So when that specific clause is breached, ideally it creates a domino effect to the legitimacy of the entire contract. So in essence, it affects the contract.
Oh, okay. Yes, thank you so much for that. There is a question over to you, Mr. Hannington. Could you please expound on the problematic issue under the PPRA construction contracts? Yes, that's a question to you.
Thank you, Cynthia. For those who are not in Kenya, PPRA is the Public Procurement Regulatory Authority. And I'd observed earlier when I was answering a question on the chat that one of the things PPRA does is to regulate public procurement and to issue forms of contract for contracts that emanate from public procurement. PPRA developed forms which relate to construction contracts. And by doing these forms, PPRA borrowed clauses from a number of standard forms, including FIDIC, but without first acknowledging that it has borrowed from those forms. And secondly, it took clauses and jumbled them together, clauses that sounded good, put them together without recognizing principles of adapting some of these forms. And by that, we've ended up with internal inconsistencies in these forms. I've said these have been highlighted by the industry practitioners, and I think it's something that especially the building experts are currently taking up with PPRA.
Okay, thank you. So let's go straight to the parting shots. Since Mr. Hannington, you're already here, perhaps you can take the floor. Then we'll go to Mr. Chair, Dr. Kimari, to give us our parting shots briefly as we end. We are also so sorry for the time constraints, but thank you so much for bearing with us. Yes, please take the floor.
Yes, thank you so much, Cynthia. I think the greatest accolades goes to our delegates who have braved the last over 2.5 hours here with us, listening and participating actively. And to me, it's also been a lot of learning, and hopefully ELS can organize something even better. Let's treat this as a primer, and we could have this as a series as suggested so that we can benefit from the knowledge shared by the panelists. And even beyond these panelists, I know they have many experts across the region, even non-lawyers, who we can drop in. So hopefully ELS thinks of creating this as a series so that we can continue this kind of discourse into the future and effectively build the next court of construction dispute experts in the region. And thank you.
Oh, okay. I thought you're still going on. Okay, Dr. Kimari, any parting shots?
Yes, sorry. Perhaps thank you for having me for this specific session. I want to thank all participants and the panelists. My parting shot, I think in 3 would be: 1, we need to thoroughly understand the unique dynamics of the construction industry, including the contract scope, appertaining risk and risk allocation, and also efficient dispute resolution methods. We have to focus on prevention measures and learn to know when to fold the bad claims. Once we have that, I think we are home and dry as advocates. Have a good afternoon.
Thank you so much, Doctor. It's been a pleasure having you here. Mr. Oche, your parting shots, please.
Thank you very much, Cynthia. Thank you, fellow speakers and participants. It's a pleasure to be here. And thank you for the organizers, East African Law Society, the moderator, and all of you for putting this space together. I share the same thoughts as presented by Huntington. We need to find a way of structuring this, given that construction law is extremely wide, so that we can have a structured way of learning in terms of series, probably in the 4 quarters of the year, so that by the end of the year we are concluding on the dispute resolution clauses and the claim clauses towards the end of the construction contract. Thank you.
Okay, thank you so much, Mr. Chen. It's been a pleasure having you here and a great honor. Mr. Okot, finally, your parting shots.
Thank you very much. And I accede and concur with all the statements made on the need for turning this into a series. And I am certain we shall be able to do that so that we roll out more such sessions. School is not only a classroom and a lecture, it's also on the job learning, in the field, on the ground, running in the trenches. And well, I've been with the construction committee for a little over a month, still trying to find my footing. And I can assure you that this is a wide area that we shall obviously, with cooperation and support, proper support, we shall be able to roll out a proper system. Thank you to all the panelists. Your eminence in the field is appreciated. Thank you to the Secretariat and to the moderator, Cynthia. All has been done very well, and I'm happy and proud. And let's keep moving on this together. Thank you.
Thank you so much, Mr. Okot. Just unfortunately, you were the the one with the least time, and I was actually quite guilty because you had a lot to unpack, a very, long and thoughtful presentation, and it was really, really hard for me to give you only 5 minutes. I was really, really guilty, but I hope we can interact more. And surely the next time you should be the first.
Next
So
time you give him an extension of time with cost.
Exactly. In fact, I feel like giving him an extension of time, but because of Zoom and all those other limitations,
Yes,
you may not
yes.
be able to. But thank you so much. It was really kind of you. I'm also so grateful for all the panelists, for the people in the audience, for their feedback. Most of them are saying that each panelist required more time. They needed an hour, so it really, really feels bad that, the panelists didn't have as much time as they deserve, but next time better. People are really grateful for the insightful discussions. They are most of the comments. Thank you, panelists and moderator. Oh, at least they've thanked me. Thank you too. Thank you so much. Everyone is saying such a wonderful webinar from Susie Odhiambo. Thank you for your time and sharing your expertise. It's been quite a pleasure to moderate on this panel with all these distinguished and esteemed panelists. I'm grateful for the honor from East African Law Society. Without taking any more time, I would like to invite Gabriel, who is the organizer to come and take us away on his last, shots, so that we can now close. Yes.
Yeah, thank you so much, my good friend, Miss Mercy Kwendo, for moderating this webinar. It's really been exciting, and it's been a learning experience for us all. We are so delighted to have our distinguished panel, my seniors, Milton Ocheng, Hannington Amol, Nicholas Echimo, Dr. Mary Kimari, and my dear chairperson, Mr. Patrick Okoth. It's really been an amazing session. We have loved it. We've learned quite a lot. It's been exciting. And what going around is, let this be a series. And I can assure you, Senior Milton and all the panelists, I'll work together with the Honorable Chair and prepare a structured learning session. As we can see, we've had over 300 participants at this session. So it shows the interest that there is in this particular segment. So we'll work together with Chair and the committee and have more of these sessions coming in. But on behalf of our CEO, Mr. David Sigana, our President, Mr. Ramadan Abubekar, would like to say thank you so much. It's been an amazing session. You panelists have really blessed us with a wealth of wisdom and a plethora of ideas and nuggets in construction law. So we are very, very grateful. Thank you for putting away your precious afternoon. I know you're all very busy. My senior Milton had to come running from court to be here. So thank you. Thank you. And we thank God it was on a day when the speed limit in Kampala had been abolished. Otherwise, I can imagine what would have happened. But thank you so much. We are very grateful. We'll be having more of these sessions coming up. We have a FIDIC Construction Law Conference coming up sometime this year. We'll be communicating the dates. We'll be working together with Chair here and our distinguished faculty of experts, some whom we have online here, to have a structured conference program. But also at our annual law conference happening in Zanzibar, we'll be having this particular conversation around the field of construction law. So you want to catch that. We'll be having 2 more sessions coming up next week. So be on the lookout for that. We'll be sharing out those flyers. Otherwise, from us at the Secretariat, to you, we wish you a very, very lovely afternoon. You stay blessed until we meet again.
Thank you.
Yeah, goodbye. Okay, a recording will be shared on your emails, and we look forward to hosting you once more.